All right. Bill in for the 6th District of the Second Florida is now in session. Honorable Mary Alice Nardella, Judge presiding. All persons having business before the court, calling here to give attention to you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. Today, we will hear the case of Young Bok Shim and Salyamad versus the BP Trust. It is case 23-2206. My name is Judge Mary Alice Nardella. Joining me on the panel today is Judge Joshua Mize. And we're very fortunate to welcome Judge Gil Patel. He's a trial court judge out of the 4th Judicial Circuit of Florida. And we are thankful for his time today and for the Florida Supreme Court who has allowed him to serve on our panel today. So thank you so much for being here, Judge. Each side will be allotted 20 minutes. We also have rebuttal, which we can save as time for the appellant. Counsel for the appellant, we typically save 5 minutes, but that can be adjusted at your preference. We are being live streamed, so please keep that in mind. And counsel for the appellant, you're recognized whenever you're ready.
Good morning, Your Honors, and may it please the court. My name is Diane DeWolf. I'm here with my co-counsel, Monica Kovaches. Together, we represent the appellants, and we collectively refer to the appellants as Your Honors, we have two main subjects to discuss today. First, there are genuine issues, multiple genuine issues of material fact that preclude summary judgment. We also would like to talk about the collateral estoppel order that established liability on behalf of Salyamad and is thus the impetus to these summary judgment orders. And I'll start with the collateral estoppel order first. I know Your Honors asked for the transcript of the hearing on the collateral estoppel, so I'm assuming that you looked at that, and I'm assuming that that did not clear up anything under that subject matter. BP asked for collateral estoppel on 3 specific issues that were argued in the 2013 case. And that was, we had argued then that BP didn't own the intellectual property. They didn't want us to argue again in the 2015 case that the license agreement.
Are catch-alls in motions not enforceable? Or are they put in for no reason at all? Because they put in their motion those 3 issues, you're right. And then they said, and any other issue that was litigated. Now I can see you making an argument that it wasn't, you say it wasn't litigated, and I totally get that. But to say they didn't ask for it, they put a catch-all. Are catch-alls not appropriate? Is that not something lawyers can do?
That's an interesting question, Your Honor. I hadn't thought about it that way. But
I mean, they put it in there, any issue that could have been litigated, which, collateral estoppel, it covers issues that were litigated or could have been litigated.
right, it's issue completely correct.
So when you say they didn't request it, I mean, they requested any issues that were litigated, not be relitigated, didn't they?
Well, they didn't. Okay, fair point, Your Honor. But what the trial court did here was they asked for these 3 specific things and anything else that could have been litigated. And what the trial court said was liability has been established, and moving forward, we're only going to go forward on damages.
Well, but that begs the question, right? I mean, I know you want to say it wasn't litigated, right? But assuming that the issue of whether or not the new knee was the same as the old knee, right? Assuming that had been litigated, liability would be established, right?
Well, it could not have been litigated though.
I know, but the issue there is not that he found liability. It's that, the kind of antecedent issue of whether or not the new knee was, could have been litigated in the old suit. That seems to be the crucial issue, is could the new knee have been litigated in the old suit or in the original suit, or was it litigated? Not did they request it, because they requested any issues that could be litigated. Not that he found liability, because if the new knee was litigated in the old suit, then there would be liability appropriately established in this suit.
Fair point.
So it seems like those are kind of tangential issues that really just don't matter, right? Or either are not well taken. The issue to me, it all boils down to, was the new knee litigated, or could it have been litigated? Is there any reason we need to look at any other issue?
The new knee could not have been litigated because the new knee, was.
And we're going to get to your argument on that. I'm just
Right.
trying to narrow the issues.
Right,
Am I right that the key and really the sole issue is, was the new knee litigated or could it have been litigated? And that's the issue we should focus on.
I think that's the issue you should focus on that.
Okay.
And now BP has said there wasn't a new need. They're saying, we made this all up. They're saying we're disingenuous on this subject and that it's just basically a knockoff, right? And I'd like to point you to the record, beginning at 17104. These are all the documents that Mr. Shim and Salumed filed with the Korean FDA to get this new knee approved. Now we have three names of knees here. We really have two knees, but we have three names, right? So we have the BP mobile knee. That was subject to the license agreement. That's what we all, Salumed, Mr. Shim got all excited about, was this great big BP mobile knee. That's what we're selling. We need more of it. They entered into the license agreement, started to get production rolling in the Orlando where Indutech was. And then FDA comes in and says, no, that wasn't approved. It's a Cat 3. It hasn't gone through all the clinical trials. You can't sell it anymore. So at that point, Salumed, they have already, at this time, that happens in 2011. Salumed has already, in Korea, they have put in a permit so that they can manufacture it there. They did that in 2010. After this FDA cease and desist order comes in, then Indutech cannot make this product anymore. So they can sell it. They can still sell it in Korea. And they can sell it in other countries. So they changed the name.
Everything you're saying goes to disputed issues, which I totally get. You think there are
Right.
disputed issues. But it seems to me the issue is not whether it was disputed, it's whether it was subject to collateral estoppel, right? Because there could be tons of disputed issues, but if you litigate those and lose or win, even though there's disputed issues, you don't get to relitigate them.
Right.
So the issue to me is not whether it was disputed that the new knee was the old knee, it's was it litigated already? It seems to me it all comes down to, was it litigated or could have been litigated in the prior suit?
Right. So I'm going to point you again, Judge, to beginning at 17104. This is when Salumed says, okay, we need to register this with the Korean FDA. Also on 17104 is, I believe it was 1010 of 11. This was after the FDA cease and desist. They changed the name. They registered with the Korean FDA to change the name. So then you see that Salumed employs 3 Korean doctors. That's it. 17124, 17143, 17161. They employ, there's contracts for these 3 Korean doctors. They run extensive tests with a company called Accutech in 2012, 2013. There's 300 pages of clinical testing. We don't do this for a knockout.
So when was the trial in the first suit?
When was the trial?
It's 2017, right?
Correct.
All right. So the issues you went through were 2013, 2014 just now, right?
Well, the cutoff date for litigation in the 2013 trial was September 2014. All the litigation, all the damages were limited to September 2014. So because this.
So counsel, understanding that was the cutoff date, collateral estoppel reaches things that were litigated or could have been litigated. Struggling a bit with the idea that we've got a 2014 cutoff, a trial in 2017. Could the issues about whether or not the fixed knee was the same as the LF knee or BP knee, could that not have been litigated in that first trial?
I don't think it was an issue in that trial. All that was it.
Could it have been? Collateral estoppel reaches things that were litigated or could have been litigated.
Well, I don't think it could have, because I think the judge cut off the litigation as of September 2014. And if you recall, another suit, BP filed another suit in 2015, which is where this really became an issue.
Did he cut it off or did the parties stipulate in the first suit?
I think there's an order where the judge accepted the stipulations and ordered.
So the parties stipulated, right?
I believe that's what happened.
So how does that affect the could have?
Well, because I think that the judge entered an order prohibiting it.
Based on their stipulation, right? They agreed to cut it off in September 14. Even taking that date, the issues with the new knee you just read to us go back to, sounds like starting in 2013 or maybe 2012. I heard some of those.
But I think you have to understand, in the 2013 trial, Cellumed was the plaintiff. We were suing BP because of the cease and desist order. We were presenting all of this, all of these damages calculations.
Wouldn't that increase your burden to bring up the new knee? You were suing them over issues related to the licensing agreement?
Well, we knew that after 2014, we had developed this new knee. So all we were suing for was the damages that we should have. If we had been able to sell this BP mobile knee, up until 2014, then we would have had these damages. And that's what we were suing for. We didn't have to bring up the new knee. That wasn't part of the case.
Could have. Let me ask you this, you appealed as both a final order and a non-final order. Why did you include the alternative? Were you in doubt as to whether or not this was a final order?
I'm sorry, you said we appealed a final and a non-final order?
Yeah, in your basis for jurisdiction, you included two. You said that this is a final order under 911 OK, and then you said it's also in the alternative, a non-final order. Why did you include that alternative? Were you worried we would find it not to be a final order?
Just as a precaution, Your Honor, no, I think it's very, very clear. This is a partial final judgment. It has the words of finality, with somewhat execution issue. We gave the judge a chance to fix it.
So counsel, with your position made clear that this is a final order, our scope of review would include the collateral estoppel order, correct?
Correct.
Are you asking us to overturn the collateral estoppel order?
Yes.
Do you do that in your initial brief?
Well, the collateral estoppel order establishing liability was the impetus for these other two orders.
Understood.
I think that,
Her question was,
did I specifically ask for it? I don't know that we specifically asked for it.
If we overturned it, will we be granting greater relief than requested?
Well, no, I don't think so. I think we've argued extensively that the collateral estoppel order was entered erroneously. Maybe
you
that
certainly
didn't
order that's
make
wrong.
it into our prayer for relief, but I mean, certainly we've argued that.
So
But I
Nancy,
know.
Counsel, you've been an appellate lawyer a long time. When trial courts grant relief not requested, we overturn them pretty much automatically, right? And say, you can't grant relief not requested, it's a violation of due process. And that pretty standard
I think,
practice?
I guess that has happened, sure.
Okay.
Yes.
If you don't ask us in your initial brief to overturn the collateral stop order, if you don't request that relief, can we grant it?
Yes, I think you can. This was a final judgment, so anything leading up to this final judgment is fair game. We argued in our.
No,
initial brief.
it certainly is in terms of, so you file the notice of appeal, you do the final judgment, and that entitles you to argue for all prior orders to be overturned, but you didn't.
Well,
Right? You certainly told us you thought it was wrong. You have a request for relief in there, and it does not include the collateral stop order.
okay, so it didn't make it into the actual request for relief, make it into the conclusion, but I mean, I think we clearly have asked for that relief based on the fact that that was the impetus for these two summary judgment orders, and we argued throughout the entire initial brief and through our reply brief, this was just wrong, and it set us up for failure. We can't put on a defense when liability has been, determined.
Counsel, go ahead.
No, go ahead.
If we did not overturn the collateral estoppel order, but we did overturn the two summary judgment orders, where would that put you on remand?
Well, it would still put us in the position of being liable and not being able to put on a defense. I believe. Because the judge, again, the Judge Jordan said liability has been established. We're gonna move forward on damages only.
Where in your brief, give me a page number where you say overturn the collateral stop order. What was
I
the-
know, I'm not saying that we did. We didn't specifically ask to overturn it. What we said was it was wrong. And it was the basis, like, so here we get this collateral estoppel order and it says you're liable for everything. And so then, BP moves forward. They move for summary judgment. They get, another order that has the adverse inference, correct? And so then they just move for summary judgment on these, we can't put on a defense for anything. So to me, Your Honor, we did ask for it because we're saying that's the impetus. That's why we got to this summary judgment. So, the implication is that they need to be overturned. Whether I said you have to overturn this, I admit it's not in the conclusion. It's not in the prayer for leave, but it was the implication.
Did the trial court in some way remake those findings that were the basis of the collateral estoppel order when they issued the summary judgment orders, which are clearly on appeal?
I missed the first part of what you asked.
In essence, did the trial judge remake the findings that were in the collateral estoppel order when it issued the 2 summary judgment orders, which are on appeal? The fact that you are precluded from presenting any defenses, the fact that the issue on the LF fixed knee was already decided, were those statements incorporated? And therefore they're an issue in their own right, not just the collateral estoppel order?
Yeah, I think that's right, Your Honor, and I think there's, I don't have a record site for you, but I know that trial counsel was very frustrated, he said at one point, if you're not gonna let us put on our defense, if you've already determined liability, we're already here, we might as well just, just go home.
He did counsel, but it was so interesting, I don't know if I can pull it up, but when he said that, I believe he referenced just the LF knee. Mr. Solnick, when he said, if we're not gonna be allowed to present the evidence that we have to show that the LF knee and the BP knee are different. What he meant to say was the LF fixed knee, right?
Correct.
And when the initial brief in the conclusion talks about the LF knee, if I have it up, you guys are also talking about the LF fixed knee, not the LF knee.
There's a couple places in the brief where it says LF knee, and I think you meant LF fixed knee.
Well, okay, so the LF knee is the BP mobile knee. They're
Yeah,
one
it's
and
the
the
old-
same.
I think we understand that. It's just a function of as we're going through the briefs, we're finding places where it would make sense if you were saying LF fixed knee,
Mhm.
but it doesn't say that.
Sales of and liability for the LF knee is a genuine disputed material fact. It's LF fixed knee.
Correct.
Okay.
I was gonna ask
Can
you
I
about,
blame this on my assistant?
um, when you talk about the damages issue and the fact that he, created that adverse inference, in your brief, what you say about it is that, quote, proving damages to a reasonable degree of certainty is not the standard for summary judgment, which is clearly, obviously correct. But this wasn't a normal summary judgment, right? He had entered a discovery sanction against your client by which he shifted the burden of proof. So to me, the question would not be, is that normally the standard for summary judgment? It would be, was that a proper discovery sanction? Was there
No.
grounds for a discovery sanction? Did he follow the, standard to impose one? And was that a proper sanction? And your brief just says it wasn't the summary judgment standard. It doesn't make any attempt to argue that it doesn't appeal, for instance, the discovery sanction. Doesn't say that he didn't have the authority to enter discovery sanction. Doesn't say he abused his discretion by entering a discovery sanction. Doesn't give us any briefing on the law concerning discovery sanctions. So to me, it was kind of odd just to say there should have been summary judgment based on this standard when the standard was imposed as a discovery sanction and not address whether it was a proper discovery sanction.
Are you asking me if it was a proper discovery sanction?
I guess what I'm asking is, can we do anything with it now, right? Because we're limited to the briefs. And what you told us was it's not the right summary judgment standard. And to me, that completely misses the point because the standard was changed as a discovery sanction. So the issue is not whether that was the proper summary judgment standard. The issue was changing the standard a proper discovery sanction. And you wholly failed to brief that issue.
Okay, I think we did brief it. I think we said,
Where in the brief did you tell me
well,
how he should have operated as a discovery sanction?
well, we said that he entered this improperly because, clearly they got all the discovery they wanted. We throw up our hands at some point. We say, we don't have this. We didn't, make this product. We didn't sell this product. We have a new product. So we don't have any discovery to give you.
I saw your
Well, that
argument.
point, actually,
Go ahead.
and I'm sorry, you mentioned that we didn't sell this product. In looking at your briefs, I was a little bit confused because your initial brief in page 16 through 17, you're complaining about the Endotech tax returns being the basis for the damages calculation. And it says in there that's wrong because the gross sales calculation fails to account for the fact you're selling the LF fixed knee. In your reply brief, page 6, you cite to the Shim affidavit and you say Endotech never sold the LF fixed knee. I can't reconcile those. Can you help me with that?
Yeah, I think that Mr. Shim in his affidavit said they never did sell the LF fixed knee. And they apparently they did not. They sold some other VP products that were licensed products. But
So if they were selling licensed
but
products,
there's nothing in the record that says that shows what they're selling.
well, and but that was part of my question here, is you're asking us to overturn the Endotech order as well.
Mhm.
And the Endotech order is a damages calculation based on 5% of the tax return gross income, correct?
Of products that we have no idea what they were. There's
Well,
not one,
but I mean, the only thing I'm aware of that you cite in your briefs that pull it out of the licensed product is the LF fixed knee. You're saying that's a new product, not subject to license agreement. Endotech was selling things before that were subject to it, correct?
they were.
Were they not selling them after? What did Endotech sell?
Genuine issue of material fact. We don't know.
Well,
Widgets?
hold on. So he entered a discovery sanction that established that as a presumption, right? So it's not an issue of fact if it's been presumed as a discovery sanction. So if you're going to tell us that that's improper, you've got to tell us why a discovery sanction was improperly entered, right? It's not a summary judgment standard, it's a discovery sanction issue, isn't it?
And again, I don't think there should have been any discovery sanction. I think we complied.
Did
They
you
eventually
appeal
got,
did you have anything in your brief asking us to overturn the order imposing the discovery sanction?
we did not. We did not specifically ask for that. Really.
Did you include any argument on the propriety of imposing a discovery sanction?
In our briefing, we did not. I see I have well into my rebuttal time. Can I save the rest for my rebuttal?
Yes, counsel.
Thank you.
Whenever you're ready, counsel.
Good morning, may it please the court. My name is Matt DeVries on behalf of the appellee, the Beagle Pappas Trust. I begin with Judge Mize's question related to whether the LF fixed knee was litigated in the 2013 case. To answer that question, the court should look at record pages 2992, which is Mr. Shin's deposition testimony that was presented at the trial in the 2013 case. It's from a deposition taken on September 10th of 2013. And within that deposition, Mr. Shin testified that the LF knee was made and designed by Dr. Pappas.
That's the LF knee though, not the LF fixed knee, correct?
Let me explain the context for which this was presented at the 2013 case, and the context arises out of paragraph 6 of the license agreement that was entered into on January 26th of 2009. So paragraph 6 of the license agreement essentially says that if Shin and Cellumed, who were defined as the licensee under the license agreement, came up with an improvement or modification to any of the licensed products, they had to notify the Beagle Pappas Trust, not only notify, but seek the approval of the Beagle Pappas Trust.
Would I find that in your brief?
I'm sorry?
Would I find this issue in your brief? I feel like I'm hearing it for the first time, talking about
Yeah, me
paragraph
too.
6 of the license agreement, so I'm struggling a little bit.
The improvement or modification in our answer brief, perhaps not explicitly, it was certainly argued below. And
When you say not explicitly, counsel, is that a euphemism for not at all? Be
uh,
upfront. Did you put it in your brief or not?
we did not cite to paragraph 6 of the license agreement in our answer brief.
The deposition testimony you're referring to, I think I know what you're referring to. And what I remember him saying is, we're coming up with a new need. Like we're coming up with a new product, but we haven't launched it yet. Is that the paragraph you're referring to?
So I can read the exact excerpt to the court, but it's a little bit of back and forth. The name LF knee comes up, and then he mentions Dr. Pappas made and designed the LF knee. And then the lawyer, who's not myself, questions him again, says the LF knee was made and designed by Dr. Pappas. And he says yes in the deposition.
The LF knee is the old knee, right? The LF knee is the same as the BP mobile knee. It seems like the new knee that everyone's referring to was the LF fixed knee.
So
Because-
you have to look at the timeline that's contained in Mr. Shin's affidavit that was filed below. And that's actually contained in the initial brief related to that September 2014 time period. So what they say in the initial brief, it's on page 5, but it says by September 2013, Cellumet obtained a manufacturing permit for the LF fixed knee. That's September 2013. He gave a deposition on September 10th of 2013. So the deposition excerpt does not explicitly reference LF fixed.
Yeah, so that means, I mean, he referenced the fact that they were gonna come out with this new knee, right? But the issue is not whether a new knee exists. The issue is the new knee derivative or a copy of the old knee? Is the new knee subject to the licensing agreement, right? How does him saying, yeah, we're coming up with a new knee, we haven't launched it yet, or it's not on sale yet. How does that litigate the issue of whether that new knee is subject to the licensing agreement?
It litigates the issue this way, because the purpose for why that deposition testimony was introduced into evidence at the 2013 trial was, and our brief does say this, that the LF knee that they're contending is different. This LF fixed knee is just a copycat. It's a copycat knee. We made that argument to the jury at the 2013 case and said, all they're really trying to do is get around the license agreement, change the name and get around.
You made that as to the LF fixed knee, not the LF knee? Because I get that the BP mobile knee, they changed the name to the LF knee. Are you saying that the closing argument at that trial referred to the new knee, the LF fixed knee?
To us, it was all, it was one and the same, essentially. It was a copy.
But that's the issue in dispute is it one and the same? You can't just assert it.
It was one and the same, or in the alternative, they had an obligation under paragraph 6 of the license agreement to notify us and advise us of any improvement and modification, and they did not do that. And those two things were certainly part of the 2013 trial, or to go to your honor's questions to Mr. Wolf, they could have been, because there was actual deposition testimony from Mr. Shin that was introduced into evidence at the 2013 trial about the LF knee, whether they wanted to take the position that it was different or the jury wanted to take.
Counsel, we're
The
still
LF
talking about the LF knee.
The LF knee is the one they concede is the same, right? They concede it's the same and they concede the LF knee was litigated. What they say was not litigated was the LF fixed knee, right? Which is what they say is their new knee. So you had the BP mobile knee, you had the name change of that to the LF knee, which they agree is the same thing. Then you have a new knee or supposed new knee that they say is different, that they call the LF fixed knee. So you're telling me if I go read the closing again from the trial, we're going to see both of those distinctions, not just the BP mobile knee to the LF knee. We're going to see another distinction made with a new knee beyond that.
So my understanding of what occurred at the trial and the closing argument was they're saying there's an LF knee, and they did argue at the trial, as I recall, this LF knee is different. And because if they were just saying it was a name change, there would have been a concession that it was a licensed product and that they owed royalties on it. But they were actually there contesting that the LF knee was
In the prior trial, they contested it. But they admit now, I think, that the LF knee issue and whether they owed licensing on that, they admit that was litigated in the prior trial and that they lost and that they owed you royalties on it. The issue is the new knee, right? Was that litigated in the prior trial?
Absolutely, absolutely. And that's why I started my presentation with the citation for Mr. Shim's deposition testimony to the court from September 10th, 2013, which lines up exactly with Mr. Shim's affidavit and page 5 of their brief, where they're saying September 2013 is when they got the manufacturing authority or permit for this new knee. And that lines up precisely for when Mr. Shim gave under a deposition testimony that it was made and designed by Dr. Pappas. The issue really is twofold. One, Mr. Shim is not truthful. He wasn't telling the truth, or they're not telling the truth about this LF fixed knee. I'm not asking the court to judge credibility on an appeal of a summary judgment order. I'm just telling the court that because indisputably tried, admitted evidence under a deposition testimony before the jury in the 2013 case. And
Counsel, how can that be if correct me if I'm wrong, but September 2014 was a cutoff for the first trial, correct?
correct.
Mr. Shim's affidavit says they didn't sell the LF fixed knee until September of 2014. So how is that possible that they were litigating the issue of damages associated with the LF fixed knee when it hadn't even been sold yet within the time frame that was contemplated in the first trial.
Because of his under oath deposition testimony that he gave in September of 2013.
Referring to the LF knee,
I'm sorry.
referring to the LF knee.
Yes, and the other evidence presented at the trial in the 2013 case and all of the collective evidence that was presented to the jury in the 2013 case about the sales of these licensed products, the copycat LF knee, their obligation under paragraph 6 of the license agreement. And I would go back to Judge Mize's original question to Mr. Wolf, that the issue really is could have. We're not here looking at the transcript to say, was it actually litigated? I'm telling you that it was at the 2013 trial, but that's not really the substantive issue. If you look at the Florida Supreme Court ruling in Topps versus State from 2004, res judicata is could, or collateral estoppel is could it have been litigated? And clearly it was, because one of their clients gave under oath deposition testimony about it, and that was actually admitted into evidence at the trial.
Did our trial court in this case make a definitive ruling anywhere that we can look that the LF fixed knee was or could have been litigated?
About 15 or 20 different times. We had a trial in this case in January of 2022. It ended in a mistrial. If you actually look at the summary judgment order, it says in there, the defendants, Mr. Shim and Selumet, have repeatedly made this argument ad nauseum. And then there's even a sentence in there that says the defendant should respect this court's ruling. And that language came directly from our briefing. The ad nauseum, they filed, I think, at least 2 motions for reconsideration, definitely one. They brought it up at the trial.
And counsel, maybe I'm missing it and I'll read it closer after oral argument, but I see broad statements like in the 2013 case, the defendants made the identical arguments, but what arguments? The argument specifically about the LF fixed knee. You're telling me that the trial court made a definitive ruling that the LF fixed knee was litigated in 2013. Not a broad statement that all the issues were litigated, but that the LF fixed knee was actually litigated in 2013 has been a finding made.
I made the same argument below as I'm making today about this deposition testimony on September 2013. So that I would have the same answer. That would have been, I think, his logic and conclusion about whether it was litigated, because you had the principal defendant giving testimony about it, inconsistent with his later affidavit that was admitted into evidence. I did want to touch quickly on the questions that the panel had for Mr. Wolf related to whether the appellants appealed the collateral estoppel order. There is a case from the Florida Supreme Court called State versus Poole from 2020 that says in order to preserve an issue for appeal, the issue must be presented to the lower court, and the specific legal argument or grounds to be argued on appeal must be a part of that presentation. I do think that law is analogous to them not explicitly appealing the collateral estoppel order. I also wanted to raise the issues of that are contained in the briefing, that their responses to the summary judgment motions were very, very limited. On the Endotech summary judgment, the only argument was Endotech is not a party to the license agreement, and therefore it cannot be held liable for unpaid royalties. Their expert in the 2013 case actually calculated unpaid royalty damages to Endotech. That's cited to in the summary judgment order. You also have Rule 5.2 of the Business Court Procedures. That is also explicitly contained in the summary judgment orders. They added many arguments on rehearing, and I am aware that there is a conflict among the district courts of appeal related to whether a court can consider an argument that is first raised in a motion for rehearing. The first, second, and fourth say in appellate.
I think it's everybody versus the fifth, right?
Yes, that's accurately summarized.
But ultimately, if it's something that arises for the first time on the face of the order, everyone's in agreement, they can have at it at the rehearing motion. If it becomes apparent for the first time on the face of the order, the trial court is making a finding that wasn't previously argued below.
Yes,
They get-
I agree with that principle of law. I do not agree that that is what occurred here. So I just wanted to know we have made that argument in the briefing. Other than that, I think you touched on the discovery violations. They didn't address that at all in their briefing. It was a very, very significant issue below of many evidentiary hearings. And their counsel acknowledged the discovery violation at the evidentiary hearing. And there really was no argument about that in the briefing. So unless the panel has additional questions for me, I have no further argument today. Thank you for your time.
Counsel, do you have a record cite on that section of the closing argument you referred to? You said they distinguish between the two knees.
I do not. Your Honor.
No. Thank you.
Okay, thank you.
I know I'm limited on time, so just a couple of things.
Counsel, you have 2 minutes. I didn't know if that would help you to know that.
Yeah, I unfortunately can see that. Judge Mize, in our conclusion, in our answer brief, in our initial brief on page 26, we do ask for relief on liability, not specifically, we don't say the collateral estoppel order, but we do ask for relief on liability. Also, I think there's a little bit of confusion between res judicata and collateral estoppel. Res judicata is what could have been raised in an earlier proceeding. Collateral estoppel is issue preclusion, and they clearly ask for issue preclusion on these 3 specific things. I think counsel's a little bit confused about whether the LF fixed knee was raised in the prior proceeding. It absolutely was not. In their answer brief, they talk about Mr. Makris, who had all this testimony about it's a copycat, it's a knockoff. You know, it's not the same, it's exactly the same product. I think you should read that testimony, because at page 15467 of the record, the trial judge struck every piece of Mr. Makris' testimony. He said he was not qualified to say what a licensed product was. And then further down, he struck his testimony that it was simply a knockoff, because he said he wasn't qualified to say he'd never held the 2 products in his hand before. He couldn't possibly tell the difference. So all of that was stricken. Makris' testimony, by the way, was part of the 2013 trial, but not until 2020, I believe. The 2013 trial is still open. It's ongoing. They're still doing post-trial motions. Makris testified in post-trial 213 in 2020. That was filed in this record after the collateral estoppel order was entered. It was never considered for the motions for summary judgment either. It was filed simply as an attachment to an evidence to exhibit list for trial, which is currently set for 2025. I see I'm out of time, so Your Honors, we ask this court to reverse the 2 summary judgment orders because genuine issues of material fact preclude entry of those 2 judgments. We also ask that you allow us to present our defense on liability.
Can I ask you further just about that? You said some of the orders in the 2013 case were entered as late as 2020. How would we rely on, I guess, for purposes of evaluating res judicata or collateral estoppel, how would post judgment orders or evidence come into that, right? How do you, in terms of like deciding what was litigated in a prior action, normally all that would kind of end at final judgment. Is that something we can do anything with if something was from the prior action that came in after the judgment and in some case after our proceedings in this case started?
It ended up in this record, Your Honor. It's in the record. It was never presented to the judge. It was never considered for summary judgment. It wasn't considered for the collateral estoppel because it was put in the record after that. They relied on it in their answer brief. So, you know, it's obviously it's in the record, what do you do? But it's never been part of this. It was only an attachment to an exhibit list for trial that presumably is set for 2025.
Counsel, thank you both for your arguments today. We're adjourned.
Thank you.